Welcome to the Chartered Institute of Arbitrators webinar on the Halliburton and Chubb decision by the UK Supreme Court. We're honored this morning to have a distinguished panel to discuss this case with us and help us to understand more about the implications, the wider implications of this decision and why it was of so much interest to the wider industry of arbitration. To introduce our panel, first I'm going to introduce our panel and then give a brief overview of the facts, just so that we know we're all on the same page and understanding the background of this case. So this morning, first we have Jonathan Wood with us. Jonathan is the chair of the Chartered Institute of Arbitrators Board of Trustees. He is also the head of international arbitration practice at RPC and specializes in international arbitration and dispute resolution relating to trade, in particular BITs or bilateral investment treaty claims. Next with us we have Flannery Qc, who is a partner at Maxwell. Louis was the, Louis is a solicitor advocate, though he is a QC. He's one of a small handful of international arbitration practitioners, solicitors who's been given the honor of being QC, and was the who the Chartered Institute of Arbitrators instructed in our own intervention in this case. Louis' background is quite deep in international arbitration. He's a frequent speaker on arbitration and civil fraud matters around the world, and he's been practicing in international arbitration for over 30 years. Next, we have Karen Maxwell. Karen is a barrister at 20 Essex. Karen used to be with the Practical Law Company and established their commercial investment and arbitration. Everyone has such deep resumes, and if you wish to know more about them, then I suggest you go back to our page and have a look at their resume. But Karen was instrumental in establishing the international commercial arbitration awareness at Practical Law before she joined 20 Essex as a barrister, and now practices in both shipping and international commercial arbitration disputes. Finally, we have Duncan Bagshaw, who is a partner at Howard Kennedy and specializes in energy and renewable energy projects disputes, particularly in Africa, where he lived in Mauritius for more than 3 years. Duncan also was a barrister that we instructed in our intervention on the case. And so we're pleased to have with us this panel this morning. Now, turning to the case. As many of you know, this case a judgment was released in November of last year. However, the interventions in the Supreme Court case and the arguments occurred many months before. It took many months for the Supreme Court to decide this case. This is in contrast to other cases that have come before the court and been decided in mere weeks. In particular, the Anka case, which was heard after this case, but actually the judgment was released before it. So this was one that the Supreme Court seemed to have taken a considerable amount of time to look at the issues. Now, why was that? Well, let's look back at how this case began. This case started with the Deepwater Horizon disaster in 2010 in the Gulf of Mexico, which made international news on quite a large scale because of the scale of the disaster. Now, there were a lot of insurance claims that came out of this disaster, and in particular, there were indemnification claims that were involved insurance and reinsurance. The underlying facts of the case are not quite as interesting as what happened in the subsequent arbitrations over these claims. In particular, the Halliburton company sought indemnification under an insurance policy that it had with Chubb, Bermuda, who was the respondent in this case. The dispute over the indemnification went to arbitration. Now, once they were in arbitration, each party appointed their arbitrator, but they could not agree on the chairman. And at this point, because it was under the English Arbitration Act, it was a UK-seated case, the courts, the commercial courts, stepped in and made the appointment of the chair, which what ended up being Ken Robeson QC. Now, once this appointment was made, there were many other insurance and reinsurance claims happening around this underlying facts of the Deepwater Horizon disaster. And so it so happened that Mr. Robeson ended up being appointed in another arbitration. However, instead of being the chair, he was the party appointed arbitrator by Chubb. Now, this dispute did not directly involve Halliburton. It was against another party called Transocean. However, Mr. Robeson did not initially disclose this. And when it became known, Halliburton asked Mr. Robeson to step aside, and he wouldn't do it unless Chubb also agreed, which they wouldn't. Now, at this point, when it was discovered, it's important to note, I think, that when the parties brought this to Mr. Robeson's attention, he wrote a letter that said that he had actually thought about whether or not he needed to disclose to the parties that he had taken up this secondary appointment, and decided, quote, that he did not think at the time and still did not think that he needed to disclose it, and that it created any issues of conflict with the case that was going on between Halliburton and Chubb. Now, the parties proceeded with the arbitration, and eventually Halliburton decided to take the challenge to the back to the courts of the UK to ask that they undo the award because of issues with his appointment not having disclosed what appeared to be a conflict of interest with the secondary appointment with Chubb. And that's how this case ended up in the courts. Now, the commercial courts initially looked at it and decided that there had not been any problem, that there had not been any instance of bias. And it's important to note that in this case, the issue was not with actual bias. It was a claim of apparent bias, which is something we'll get into with the panel a little bit further. Now, the appeal was, the commercial court decision was appealed to the Supreme Court of the UK, and the court decided to open it up to interventions from interested parties. And there were 5 independent interventions from the Chartered Institute of Arbitrators, the London Center for International Arbitration, the LCIA, the ICC as well, and then from the LMAA, the London Maritime Arbitration Association, and GAFTA, which is a commodities arbitration group, as you all know. So first of all, let's talk about the intervention by the Chartered Institute of Arbitrators. This case revolves around whether or not an arbitrator has a duty to disclose certain things. And I turn now to Jonathan, and I want to ask you to explain, if you will, why it was that this issue in this one case, in this one region, was of such great interest to the Institute that we felt it worth our while to intervene and actually make a formal intervention in a Supreme Court case.
Okay, thank you very much, Mercy, and welcome to the many of you who have joined us this morning. I think we had 1,600 registrants, so that is a fantastic audience from all around the world. And I think it's important to note that this case does have very important ramifications for the worldwide arbitration community. I mean, UK and London in particular, for many years, has drawn in disputes from international businesses of a wide variety. The sectors that bring their disputes here include pharmaceuticals, technology, infrastructure, and the Deepwater Horizon incident itself, which took place in an explosion and an oil spill in the Gulf of Mexico, involved the offshore energy industry, maritime industry, commodity industry, infrastructure, as well as the international insurance market. And there's been developed in the UK, what I describe as an arbitration ecosystem. We've got organisations who resolve these disputes from many sectors, as Mercy has mentioned. London Maritime Arbitration Association, LCIA, LCAM, all the commodities arbitrations, the London Metal Exchange, GAFTA, and the Cotton Exchange up in Liverpool. So the eyes of the world look to what is happening here in England and how English law and the English courts navigate their way around the issues that arose in this particular case. Now, it's often said there are two sides to every case, but sometimes there are more interests than those of just the parties, and this was just one of those cases. And as in those sorts of cases, the court permits an intervention by those interested parties, even though it is a private interest, a private dispute, and not one of public general interest. So, as Mercy mentioned, there were interventions by the LMAA, GAFTA, the LCIA, the ICC, and of course, the Chartered Institute. So why did the Chartered Institute decide that this was such an important issue that it should intervene to deal with this important issue of disclosure on the part of an arbitrator and the whole issue of independence and impartiality? Well, the Institute itself has a membership of over 16,500 worldwide, and over half of those come from overseas. And in addition to education and training and providing guidelines to its members on the conduct of arbitrations, it provides and maintains standards of professional conduct over its members. There is a code of professional and ethical conduct, and the Professional Conduct Committee has power to investigate and take disciplinary action for serious breaches which might amount to misconduct. And Rule 3 of the code deals specifically with conflicts of interest and the duty of disclosure, which relates to independence and impartiality. So the issues that were raised by the Halliburton case feed into the whole debate on ethical standards and the duties that relate to arbitrators when taking appointments. So on that basis, that was why it was felt an imperative, if you like, that the Chartered Institute represented some of the views, not just from the UK, but from the wider international community as to what might be best practice and indeed what the law might or should be in relation to the duty of disclosure on the part of arbitrators. And those are the issues which our panel are going to discuss today. We instructed Flannery Qc, who led Duncan in the Supreme Court, and we also have with us Karen, who actually acts as an arbitrator, particularly in one of the sectors, well, more generally, but in one of the sectors which was represented, which was the London Maritime Arbitration Association. So, Mercy, back to you, please.
All right, thank you, Jonathan. Now let's turn to Louis, who, as we've said, we instructed in the case. Louis, let's talk more about the issue of the arbitrator, Ken Rokerson's behavior in the case, and what exactly the conduct of an arbitrator, the implications for the conduct of an arbitrator that this case has generally. Why was his behavior at issue? And now what for arbitrators going forward? What does this case mean that they need to think about?
Oh, those are two different questions. Right. Question one. To remind people from your fact summary, Rokerson had been put forward by Chubb as their #1 candidate for presiding arbitrator, for chair. And this was objected to by Halliburton for other reasons, but he was objected to. That went to Mr. Justice Flo, who nonetheless installed him as presiding arbitrator over the objections of Halliburton. So he knew at that point in time that he wouldn't have been Halliburton's first, second, third, or 15th choice. Nonetheless, 6 months later, Halliburton, using the same legal team, and this is important, they use the same legal team, Chubb using the same legal team, I'll wake up in a minute, Chubb using the same legal team appointed him as winger in a dispute arising out of Deepwater Horizon for Chubb, where it was the same issue, namely the reasonableness of the settlement that had been made by the contractor in that case. And a month later, he takes a third appointment for another insurer, but for the same legal team at Clyde's, and it's the same issue, the reasonableness of the settlement. So the same issues are in 3 arbitrations. At that point in time, if he had been approached by Halliburton, who, if they had found out immediately, it took a while for them to find out, but if they'd been approached immediately before any of the 3 had really got going, and been told by Halliburton, hang on a minute, first of all, you haven't disclosed this, that's bad. We'll come back to that. But now let's assume that you had told us or had asked us in advance if you could accept those appointments. Our question would be, how can you guarantee us that you won't be infected by information that arises in one of those 2 arbitrations that infects your thinking and yours alone as the common member of the tribunal, to a point where obviously Chubb will be aware because it's the same legal team, it's the same party, and the other insurer, they're the same legal team in the other case as well with the other insurer, so that they'll effectively be party and privy to information passing between those 2 arbitrations and what's going on in this one. We'll be in the dark. Can you guarantee us a level playing field? Answer would have been, or an honest answer would have been, no, absolutely not. And at that point, I would say the die is cast. But what happened was he got found out. He didn't voluntarily disclose it, but he got found out that Halliburton had found out that he got appointed. And his first reaction, as you quote, was when they first approached him, they said, have you heard of these things called the IBA guidelines on conflict of interest? It's like the entire globe knows about these guidelines. And you'd like to look at Article 5 and Article 3 and just say whether you think you've got a problem. Reply, I do not think, and I did not think that that they required me to disclose, meaning he had thought about it at the time and decided not to disclose. And this is at a point where he's been appointed over their heads, over Halliburton's heads, he's over their objections. He's simply, he should be so astute to anything that might call into question the decision to appoint him in the first place presiding arbitrator. And yet he consciously made a decision. Now, this is a point we made in the appeal, but unfortunately, for reasons I won't go into, it was not picked up or taken by Halliburton. They expressly disavowed that approach to the issue, which we think was missing an open goal. So not only did it not get picked up, we got a coded ticking off by the court for even suggesting that it was a matter that should be brought up, because the approach that had been taken in the first instance Court of Appeal was this is entirely an innocent oversight, a mistake, an inadvertent failure to disclose, which cannot have been the case. But the problem in these cases where there is a challenge is the inability to get into the mind of the arbitrator, to haul him up into cross-examination, put him in the hot seat or hot stand in the court, and cross-examine that arbitrator to pieces, I think in this case. You never get that chance. So in the sense that there is a mens rea element in this failure to disclose, you'll never be able to discover it. And you can't even allege it as counsel because of the difficulty of alleging any sort of bad faith or improper conduct without good evidence. So it's a big conundrum. But the Supreme Court decided, along with the Court of Appeal in first instance, that there were no grounds for giving rise to justifiable doubts as to his impartiality. largely on the basis of how events panned out afterwards. But that's another issue we'll, I'm sure that others will talk about later. What's the implications for arbitrators in the wider world? No real difference. Disclose. What the Supreme Court said, and Jonathan, you'll be interested to know that. Well, I've just spotted, because I was looking at Article 11 of the CIArb's rules, but the Supreme Court said, while the test under 2024 is there are circumstances giving rise to justifiable doubts as to impartiality, they also decided there was a duty of disclosure. It'd been argued by Chubb there was no duty of disclosure, and the duty that was formulated by the court was to disclose any circumstances that might give rise to justifiable doubts. In other words, if you're in any sort of sense reasonably suspicious that it might do it, disclose it. The point about Article 11 I've just noticed is that the requirement to disclose under the CIArb's rules any circumstances likely to give rise. In other words, it's a lower test. The Supreme Court has set the bar higher than the CIArb rules. And I'm with the Supreme Court on this. I think if you're in any doubt as to whether to disclose, you should have a duty to disclose. So any arbitrator in this case will have to disclose. One of the reasons the court gave, quite amusingly, I think, was that at the time of this whole fiasco coming up, the law was in an unclear state. So he was allowed to sort of not disclose. No, don't get that. There was always a duty to disclose, but never mind.
So it's important to note that this was not done through an institution. His appointment was directly from the courts because this was an ad hoc setting. Would this have turned out differently had this been an institutional challenge?
Undoubtedly. It wouldn't have survived if this had been in the ICC or the LCIA. He would absolutely not have survived a challenge. I have no doubt at all. Not least because there is a slightly more subjective test in those rules. It's in the eyes of the parties, and clearly one of the parties here would have been calling into question his impartiality. I mean, the basic question you've got to ask is, what was he thinking? What was he thinking? And what were clients thinking? What were they thinking? That, yeah, it's fine. You can just take the appointments. We won't say anything. You won't say anything. I mean, just nuts. But there we are. Don't do it again.
Yeah, just coming in here before we turn to Duncan, I just think it's worth reminding ourselves that the Arbitration Act in England does not expressly provide for a duty to disclose. We were reliant on Section 24, the ability to challenge where there are justifiable doubts. And so many of the institutions and the UNCITRAL model rules make an express provision for the duty to disclose. So, we fell behind the mark, if you like, under the Arbitration Act, and it had to leave it to the Supreme Court to establish once and for all. I mean, this was the findings of the courts below, that there was in fact a duty to disclose. So, we were behind the game, Louis, from that point of view.
Yeah.
But yeah, Mercy, over to you.
All right, actually, next I'm going to turn to Karen. Karen, as we've mentioned, you sit as a maritime arbitrator in your practice. And one of the things that the Supreme Court discussed in their analysis was this notion of the custom and practice of a particular field of arbitration. The LMAA and GAFTA had particularly intervened on this topic, saying that this is sort of the way things are done in certain portions of the arbitration industry. So my question to you is, as a maritime arbitrator, what does this mean for you? And there actually seems to be quite a lot of gray area left regarding this concept of custom and practice, and how you handle this going forward.
Yeah, I mean, I think that is a really good question. I'm not sure I know the answer, but I'll try and talk about it a little bit and try and identify where I think there are still areas up for debate. And I think to do that, one of the key things that we need to understand is the statutory background to the duty to disclose. And in particular, I think the key point to bear in mind is that there are provisions of the Act that are mandatory. And by that is meant that it's not possible to contract out of them, and it's not possible to modify them by contract. And if you look at Section 1 of the Act, which sets out the basic principles, it talks about party autonomy, but what it says is that party autonomy is not unlimited. It is subject to public interest safeguards. And those safeguards take the form of certain provisions that can't be modified or contracted out of. And I think, you know, key to trying to understand what the Supreme Court have decided is realizing that the provisions that they rely on in constructing this duty, so Section 33 and also Section 24, they are both mandatory. So in theory, you shouldn't be able to modify them with your contract. So against that background, if we look at what the Supreme Court decided and how they analyse the duty, what they say is that the legal basis of the duty is twofold. They say, first of all, it's a component of Section 33, so it forms part of the array of duties that are imposed on an arbitrator by virtue of accepting an appointment. But secondly, they sort of overlay this contractual analysis and they say, well, it also arises as an implied term at the point at which you accept an appointment. And if you drill down to the judgments, I mean, actually, Lord Hodge talks very little about the contractual aspect. I think he only mentions it once. And it's pretty clear that for him, a non-disclosure is a breach of a mandatory Section 33 duty. It's really Lady Arden's analysis that's a little bit more nuanced, I would say. And as she sees it, the primary duty is Section 33, but then there is a secondary obligation that she says is rooted in both Section 33 and the contract. So I think one of the first questions I had when I read the judgments was, well, why do you need this contractual analysis? It doesn't seem to add much in terms of remedies, because although a non-disclosure would amount to a breach of the implied term, you're never going to be able to get damages for it because arbitrators are immune. So why have the Supreme Court adopted this analysis? I think the key to it is in Lady Arden's speech, and she says that she thinks that by rooting the duty in Section 33, but also in contract, you then get a legal basis for the idea that the parties can agree to modify the scope of the duty of disclosure. And to my mind, that is immediately problematic because it raises the question of whether you're trying to cut down what are meant to be mandatory duties. So I think that's in theory problematic. In practice, does it matter? Well, I think in most institutional arbitrations, probably not, because as Louis has mentioned, that the rules, the institutional rules generally tend to impose a wider and a more onerous duty of disclosure than would arise under the Act. So that's fine because you're not trying to cut down your mandatory duties by contract. So that there's no issue there. And I think, you know, the English courts have always been really keen to emphasize that the IBA guidelines, for example, are not the same as English law. So we do diverge there, but English law is a narrower obligation. So that's fine as a matter of practice. I think where potentially you run into problems is where you start thinking about the sort of point that the LMAA and GAFTA raised on their intervention, which is essentially the idea that there is a custom and practice which, I mean, to put it crudely, excuses an arbitrator from what would otherwise be a duty of disclosure under the Act. they gave evidence that actually it's very common to have multiple appointments. It's not perceived as an issue by the users of arbitration. It's understood that the multiple appointments won't be disclosed. And therefore you sort of arrive at some sort of implied agreement that disclosure is unnecessary. So I guess the first point to make is that, you know, when you're talking about custom and practice, you're always talking about something that's uncertain in scope. And indeed, the custom and practice will vary from industry to industry and from arbitration to arbitration. The Supreme Court actually gave quite a strong steer that they don't want to see disputes about the scope of any relevant custom. And Lord Hodge says that he thinks it would be a jolly good idea if institutions like the LMAA now go away and sort of tighten up and amend their rules to make clear exactly what sort of disclosure the parties can expect. But I think it's at that point that you might then sort of face that question head on as to whether or not any rules that seek to cut down Section 33 are in fact enforceable. And I think for individual arbitrators, it sort of raises a further question, which is, you know, if it is possible to limit your duty of disclosure by contract, should we all be amending our terms of appointment to cut down what we say we've disclosed? You know, should we be posting on our websites to say, I haven't investigated what arbitrations my colleagues in chambers have been involved in. I haven't looked into that, and I'm not going to disclose anything about it. I mean, I think I can see that potentially, you know, disclosure is a heavy burden on arbitrators. The Supreme Court have left open the question of whether there's a duty to investigate, but if there is, that could become unworkable. And so is the answer that we all short circuit this in the manner that the Supreme Court seemed to envisage by some carefully worded terms and conditions. And if we do arrive at that point, are we arriving at a destination that was contemplated by the Supreme Court? I suggest not, but it does seem to be the logical conclusion of the way they analyse this duty. So I do think there are some grey areas that probably will need to be debated in future cases.
One of the questions, Karen, if I can just interject before we get to Duncan, one of the questions that's come up on the chat is something you touched on, which is the immunity of arbitrators. The question was, what is the personal liability of an arbitrator in the event of, you know, a failure to disclose? Yeah. Was it contemplated in Lord Hodge's judgment? I mean, I think he referred to thrown away costs could be an issue. I mean, I'm not sure how serious that was, but I think that was one of the points that he did make, wasn't it?
I think, I don't quite understand that suggestion, because I think insofar as they're being claimed as damages, that would be difficult because of immunity. Under Section 24, if the court decides to remove an arbitrator, it can make an order requiring the arbitrator to repay, I think it's just fees and expenses. So there isn't any express provision, I think, in relation to wasted costs. I suppose the costs of the court proceedings, if the arbitrator shows up, might be ordered against the arbitrator as a participating party. But I don't think it's quite as straightforward as Lord Hodge suggests. And obviously it wasn't, I think, an issue in that case, so he didn't need to come to a considered view about it.
We might just all dust off our professional indemnity policies.
I mean, I think the whole question of what is discussed in the judgments, but whether there is a remedy for breach of the duty is quite problematic, and therefore is it a duty in the sense that we would normally understand that word? Possibly not.
Mercy, back to you.
And thank you, Jonathan, for pointing out. If anyone has questions for a panel, please feel free to put them in the chat. We are looking at it, and we will look at it a little more closely after everyone's had their say. So if you have any burning questions, please put them in there. let's move over now to Duncan. Duncan, on the theme of gray areas, another gray area that seems to have arisen in this case is in particular the timing of an application for removal. The court looked quite, gave quite a lot of weight to that, but even that has significant implications on what an arbitrator could do at certain times and how that would affect their behavior or the overall outcome of a challenge. What is your view on the implications on timing?
Thanks, Mercy. Can I just, before I speak, can I just echo what Jonathan said, how great it is to see such a global audience listening to us. It's really inspiring. On the question of timing, it was a very interesting feature of the case because, as I think I commented to Louis when we first got the judgment, it was as if the Supreme Court had agreed with Halliburton about everything, pretty much, except for the result of the case. Which they found the Court of Appeal had got right. And this timing point was really at the heart of that, because the court agreed there was a legal duty of disclosure in these circumstances. Failure to disclose could give rise to a perception that there was a lack of fairness at that time. The arbitrator had breached that duty, but that by the time the matter came to the hearing, in fact, the fairness had gone away. And at that point, which is the relevant time for assessment, the court should conclude that the arbitrator shouldn't be removed. So I haven't spoken to, and I'm not giving away any confidences, but one can imagine Halliburton's legal team jumping up and down and saying, what do we have to do to win? You know, we seem to have won all the arguments and lost in the result, which is interesting. From a legal point of view, the timing point, it derives from the wording of Section 24. And Section 24 says that an arbitrator can be removed on the grounds that circumstances exist that give rise to justifiable doubts as to his impartiality. And exist is taken to mean present tense exist at the time of the decision. And Lord Hodge specifically referred to that present tense analysis. And he mentioned a case in an entirely different area of law altogether, R and Goff, in which Lord Goff said that the court's decision on bias would be made from the available evidence, knowledge of which would not necessarily be available to an observer in court at the relevant time. Lord Hodge said that the arbitrator's measured response to Halliburton's robust challenge disclosed that it was likely that references 2 and 3, those are the second and third arbitrations in the series of 3, would be resolved by the preliminary issue, and there wouldn't be any overlap in evidence or legal submissions between them and reference 1. And when the awards were handed down by tribunals, which of course included Mr. Okerson, he turned out to be right, not surprisingly, that his prediction was correct. References 2 and 3 were resolved by the preliminary issue. If that had not been the outcome of the preliminary issues, it was said, Mr. Okerson had offered to consider resigning. In other words, if my tribunals had decided differently on the preliminary issues, the case may have gone in an unfair direction, and I would have therefore stood down. And that's an interesting conclusion, because Lord Hodge accepted, and I think Lady Arden even more strongly accepted, that the potential unfairness from the overlapping appointments probably did give rise to a perception of bias when Mr. Okerson failed to disclose it. Mr. Okerson said he probably would have resigned if the decision on the preliminary issues had gone the other way. That seems to be an express acknowledgement that all the decision makers agreed that he could not have continued but for the decisions made on references 2 and 3. Those decisions were made by tribunals of which he was a member. And I struggle with the idea that, having been tainted with a perception of bias, not actual bias, and we don't need to go that far, but a perception of bias, he can then make decisions which pull him out of the potential unfairness which is thereby perceived in practice. That seems to me to be a little bit bootstraps, as it's sometimes called, taking oneself out of a position of potential unfairness by making decisions that render it irrelevant. I wonder whether potentially the court may have gone a bit too far on the present tense analysis by saying that, taking into account facts known at the time of the hearing, should be extended to mean considered from the point of view of the court at the time of the hearing, and forgotten that once a perception of fairness exists at a point during the arbitration, the party in Halliburton's position may well say, well, we've lost confidence in this arbitrator. We have a legitimate fear that there's a perception of bias on the part of the arbitrator. How is it that the arbitrator's own decisions, or a panel of which he forms part, can pull him out of that? The preliminary issue decision, which apparently changed the situation, was an issue decided in favor of Chubb in both cases. Bearing in mind, Chubb are the party trying to keep the arbitrator, and Halliburton are the party trying to remove the arbitrator. I'm not sure how those decisions can be said to put the fair-minded observer's mind at rest. So I fear that this decision may go a little bit far.
Yeah,
Sorry.
Louis, I mean, okay, so, I mean, there's one thing we've got to think about, and this is how this looks to the rest of the world. And Louis, you have quite strong views about the duty of disclosure. I think you almost have a view that there should be a presumption of disclosure. You expounded that sort of view. But let me come back to how these proceedings started. I mean, what you've got to remember is that an arbitrator owes a duty to both parties, and Ken Rokerson actually did agree to withdraw. But was the real problem in all of this when his appointment was affirmed by Mr. Justice Flo in the first place? I mean, if that hadn't happened, we would never have been in the Supreme Court. Is that where the real mischief arose?
Yeah, I think it is. It's certainly, when you're looking at cause and effect, one of the major contributing factors was the appointment after a contested hearing. But my take on that was he should have been hypersensitive to anything that might have called into question his impartiality at that point. This was $100 million dispute. This wasn't a 50 grand dust up between a subcontractor and an electrical fitter. This is $100 million. This is big bucks. And he had been appointed over the objections of Halliburton. I regret that we didn't put forward an argument that I think now should have been put forward, and Halliburton didn't make it, which was, once you have decided that as the court did, that there was a duty to disclose, and that was part of Section 33. And there's a point that Karen made I want to come back on in a second on that. But once you decide there was a duty to disclose, and once you decided that that was breached, there should be a presumption of apparent bias. There should be a presumption that there are justifiable doubts, unless the arbitrator can say, no, I'm innocent for the following reasons. But the buck should pass to the arbitrator at that point. It shouldn't, the party who is objecting, who can say, you had a duty to disclose, you didn't disclose, this was material. I'm now in a position where I ought to get home on my Section 24 challenge, in the way that if it had been in the ICC, the LCIA, it would have been banged to rights. But we've got the law as it stands. The one flaw I see in the Supreme Court's reasoning is picked up in a point when, as Karen said, it's part of Section 33. That doesn't deal with the point that both the CIArb and the Scots, thank you, Brandon Malone has popped up in the chat to remind us that the duty is expressly encapsulated in the CIArb Article 11 and in the Scots rules. It's encapsulated to cover somebody who's approached as an arbitrator. In other words, what the Supreme Court have done by saying it's part of Section 33 is saying that's imposed on anybody who is appointed as an arbitrator, not on anybody who's not appointed. Your Section 33 duty doesn't kick in until you're appointed. So if you're approached as to be appointed as an arbitrator, what is the basis of your duty of disclosure? Answer, look at the UNTITLed rules, look at the CIArb rules, look at the Scots rules, and there you have it expressly on anybody who, quote, is approached to be appointed as an arbitrator. And that's quite a glaring failure of English law. I know it's the United Kingdom Supreme Court, but Scots have got their own carve out, and it's the proper carve out. It's one of the many reasons why I think the Act now needs to be updated to make clear, A, there's an express duty of disclosure, and B, it covers anybody who's approached to be appointed, not part of Section 33, because it doesn't work.
I think that partly may explain the contractual analysis, because if you look at the implied term itself, they say it's a term that I have disclosed everything that I need to disclose. So it sort of has that retrospective effect.
But when does that contract come into being?
Well, yeah, upon appointment.
Just by being approached.
But it only matters if you're appointed, but you then get the retrospective effect by means of this implied term. But to my mind, that brings then a whole host of other issues.
Yeah, that's very unworkable.
And Karen, sticking with you, there's a question in the chat that was directly at you on the duty to investigate. So once an appointment has been made, you mentioned that there was this possible duty to investigate what's going on even in your own chambers. But this duty to investigate, is this on the parties? Is this on the arbitrator? Currently, the practice is that you wait for disclosures from the arbitrator, but now do the parties get to go and dig and investigate and ask their own questions to a whole new extent? And is that reasonable?
Well, I mean, to deal with the investigation point first, I mean, I think there's another sort of potential conflict with mandatory provisions here in terms of Section 73. I mean, Section 73 says, if you don't raise your objection to the arbitrator in good time, you lose the right to object unless you can show that you didn't know about the facts you rely on, or that you couldn't, with reasonable diligence, have discovered them. So that sort of impliedly, I think, puts a duty of investigation on the parties. But I'm wondering if post Halliburton, a party could now say, well, that investigation is pointless because I can just rely on the arbitrator discharging his or her duty to disclose. So effectively, there's no content to any investigation obligation. I think there is quite an interesting policy question around whether parties should assume some of the burden of locating and disclosing the relevant information. If they've got questions, perhaps they should be expected to ask them. I don't know. In terms of chambers, I mean, I mentioned the chambers situation because I think I've read about a challenge that's proceeding, not in this country, I think it may be somewhere in the States, which is based on
Miami.
Yeah, it's that one, yeah. And it was based on appointments or cases that the arbitrators, exactly, it's the colleagues in Keating chambers had taken on. So although, I mean, obviously, Halliburton itself doesn't address that situation. There's no duty of independence in English law. One of the reasons the DAC gave for that was that they didn't want to cause problems for people in chambers who are, very used to appearing against each other or in tribunals with other members of chambers. So, but nevertheless, it does seem to be an issue that's sort of bubbling away. It hasn't been addressed in this decision. But I think the point that I was making is, can you and should you just short circuit all that with your terms and conditions?
The solicitors' take on it, and a slight correction, Mercy. I'm in the rather odd position at the moment, being a solicitor and a barrister, because I was admitted to the bar last year. But as part of misconduct rare, as part of a firm, if I'm approached to act as an arbitrator, the first thing I do is put out a conflict search. It's just second nature. You absolutely have of course you have a duty to check whether there is something, even if it's not codified in any statute or contract or anything at that point in time. Because obvious reasons, if you do the conflict search after you've been appointed and find there's something, you've got to resign. It's all a bit daft. but you do have to make a disclosure, I think, at that point. And one of the people in the chat, Chris Dancaster, has made the obvious but very good point that just have any doubt whatsoever, disclose. There's always another appointment, as he puts it. It's this sort of sense that you're so desperate. I can't throw away that appointment. I can't throw away that appointment. No, disclose. If you get found out later, bang, it's not going to look good. And
well, there has been commentary about you know, how anxious arbitrators are to chase the work. I mean, Ken was not in that position. He was very well instructed indeed, and one could never level that accusation at him. But there is this concern that people are, shall I put it, less than frank, or don't fulfill a complete duty of disclosure because they like to chase the work. And I think if that's what motivates people, then they're in the wrong job, frankly.
Yeah.
Jonathan, can I
got to disclose? Yes.
Can I comment on that from a, if I can say this very cautiously, from a slightly younger perspective, someone who would like to have arbitrator appointments. I just want to say to all the younger people listening, this note of caution, no matter how keen you may be to get arbitrator appointments, applies, if anything, more to you when you're starting out your arbitrator career. Because the last thing you want is to get one of your first appointments and for it to end up in a great big mess and fight over whether you should or shouldn't have disclosed something. It's the last thing you want. It's a terrible way to start. So it may feel at the beginning that the point that Louis made, there'll always be another appointment. That may not feel right at the beginning. You may think, well, I've got to grab whatever I can get. It's absolutely not the case. And the last thing you want is to end up getting mired in some horrible ordure of dispute about whether you should have been appointed or not, or whether you should have disclosed.
Yes.
So, even if it's a $50,000 case, as Louis said, it doesn't matter how much the case is worth. You've got to be absolutely strict.
There's nothing worse in the world than seeing, being involved in an arbitration and then seeing a claim form from the commercial court land on your desk.
Naming you as a respondent.
It is a nightmare. But I think that's very sound advice, Duncan, to those just, you know, sort of entering into taking up those positions. Time's running on. I mean, Mercy, the issue of confidentiality.
Yeah, thank you, Jonathan. I was just going to say, we still haven't touched on another one of the significant gray areas that may have been presented in this judgment, which is confidentiality. The Supreme Court made a point of saying that an arbitrator also has a duty of confidentiality to the parties whose dispute they're deciding, and balancing that against this duty of disclosure. Any comments on that?
Yeah, I can comment on confidentiality because it was one of the reasons why there was a delay in the judgment. The hearing had taken place in November. We were chasing the Supreme Court in February, March, April, May, and June. And then in June, suddenly we got a communication from the court, which clearly emanated from Lady Arden, asking us all to think very hard about the ramifications for disclosure of appointments in related cases, the ramifications for the duty of confidentiality, which is also imposed on arbitrators. And I think both the protagonist parties and the interveners all sort of went, oh yeah, I hadn't thought about that. Yeah, oh yeah, actually those are good questions. And there were 10 questions, and they really cleverly asked us to submit the answers by the 31st of July, knowing that that was the last day of the term, giving them, of course, the long vacation to write the judgment and take it into October, as they did. I think it finally came out in November. And but the questions were good because there were issues relating to what you could disclose if you are approached in one arbitration to act as arbitrator, and you've been appointed in the first arbitration, and you go back to the first people and say, I've been approached to act in this one. Do you mind? And then there's the second one. Well, actually, I have to go and tell the second. Do you mind if I tell the first people? Because and you get a little bit in a higgledy-piggledy because you've got to work out what you can tell to who. The sort of answer that was given by the Supreme Court, a little bit cloudy, but basically it's, you know, it's all right you basically don't say anything about the dispute, and you don't necessarily have to name the other party if there's a common party. You can just say, I've been appointed in a related matter, if you have to. I mean, you need to be able to go back and double check, as should have happened in this case and didn't happen, which is how it all got so muddled.
I've always found that there's been a bit of a code amongst the arbitral community as to disclosing whether they're involved or not. You know, I couldn't possibly say this, could I? But you may think that kind of code. So that's, in a practical way, that's one of the ways that this very knotty issue arises. You know, what can you say? I mean, the fact of the arbitration that one might be involved in, I think, is disclosable, and one or two other points were made by Lord Hodge, but it did, as you say, exercise the minds of all concerned as to its impact, you know, confidentiality and privacy. I don't think, from a personal basis, I've never had to deal with that as such as an arbitrator, but certainly when I've dealt with it in appointing arbitrators, as I say, there's a sort of code emerges as to how you sort of give a nod and a wink that this would not be a good idea for them to be appointed or otherwise.
If I could just throw in one last question to everyone, are there any implications of this decision as to the popularity of London as a seat, or because we know, according to the research, that it is still the most popular seat for arbitrations? Does this have any implications for the popularity of London? Or
Louis.
Oh, I knew you'd throw that one at me, Jonathan. There would have been, if it hadn't gone to the Supreme Court, one thing that really troubled me, and I know troubled Jonathan and Duncan, was the fact that at first instance in the Court of Appeal, Rokerson had been named as M in Bond style, and there had been a sort of in effect oh, it's all right, he's a good egg, he's got a sterling reputation, of course there are no justifiable doubts, off you pop. And there was I was horrified by that, because of course the wider world would not know, and indeed Halliburton wouldn't have known, as it were, as a party, anything like that. And of course, to conceal M's identity was, I think, a retrograde step. So good on the Supreme Court for disclosing his identity, but there's still a nagging sort of, oh, it's all right, it's an old boys club and he's one of us and we can trust him. It's still there. Will it have an impact? I don't think so. There are many, many threats to London's standing as a premier arbitral centre, but I don't think this decision is one of them.
I tend to agree with that, Jonathan, for a slightly different reason, which is that Louis is right. I was very concerned about the M is a good egg, and that's one of the factors we'll take into account in deciding that he shouldn't be removed, but we won't tell you who he is analysis. Partly because, putting my younger practitioner's hat on again, citing someone's great eminence and experience as a reason for why their bad behavior should be excused is a very odd thing to do from the point of view of someone who doesn't have the experience at that level. But putting it another way, I think the decision was helpful, as Louis says, because putting my American hat on, or my Nigerian hat, or my Chinese hat, I might say this does rather look like the English system celebrating arbitrators who, it seems, have been guilty of doing things that the rest of the world says, well, we're not very comfortable with that. And I think the decision, although it decided not to remove, redresses some of that and gives some reassurance to the rest of the world that we are tightening up, maybe to a fault. Maybe the extent of disclosure that Louis was talking about earlier, disclose, is going to go too far at some point. But I think there's an appetite in the rest of the world for more disclosure than the culture behind the original decision here tends to indicate.
I mean, I think one of the points that occurs to me is that this shows how the common law, the English common law, is able to navigate its way round many different situations and deal with it in a flexible manner, which kind of meets all the various interests that were heard before the Supreme Court. And I think, okay, the decision itself, you know, you talk about that, but it is a fairly masterful piece of navigation, to use a maritime expression. I don't know how you feel it affects your practice or the practice in England, Karen. Do you think it'll affect London?
I don't really. I mean, I endorse. I also sort of had perceived that sort of good egg thinking, especially in the first instance judgment, where it's
somebody from the same chambers.
Well, you know, he is a good egg, but that's not necessarily a good basis for a decision. In terms of my practice, I mean, I conduct my practice through chambers, so we've got sort of platforms for doing conflicts checks, and we're very careful about that. So I don't particularly think it's going to massively affect things, apart from just being extra careful, I suppose, that we do make sure we err on the side of caution when disclosing. I think the other thing to bear in mind is that, you know, most arbitrations will be subject to some form of rules. So it'll be quite rare, I expect, that you'll be relying solely on the existence of a common law duty. So in that sense, you might say, well, it's not going to be directly relevant to many arbitrations. But I think the overall message is probably a positive one from the judgment.
And I think that applies worldwide. I mean, again, as I mentioned at the outset, you know, the Institute itself, we have, you know, half of our membership is overseas, 6,500. It's probably time now to revisit those rules and perhaps bring the more, you know, the might issue and the likelihood issue, Louis, that you referred to. Perhaps it's time to revisit those rules and, you know, so that it has a worldwide impact. But overall, I think London will survive despite this particular case. I think it will maintain its, you know, be one of the preeminence things, preeminence areas.
And I'm afraid of, just like that, our hour has gone. And I think that one of the things that we can all take away is disclose, disclose, disclose. If nothing else, that's kind of the takeaway from this analysis in this case. So unfortunately, since we've come to the end of time, I'm going to thank the panel, and the chat is still quite active, still going. So take note if there's any questions that you'd like to respond to people directly later. But thank you, everyone, the over 800 people who joined us today to listen into this discussion. Pretty great turnout rate. It just shows how important these issues are to practitioners worldwide. And on behalf of the Institute, I would like to thank all of the panelists for their great analysis and for giving their time to help us understand these issues better.
Duncan, your cat is visible behind you.
Yes, it's not a filter.
No, you are not a cat.
I'm not a cat. It's just there happens to be a cat in the room. I can't control it, so I'm afraid it does what it wants.
Full disclosure.
Full disclosure. He's not alone in the room. He's disclosed.
Thank you very much, everyone.
Thank you.
Yeah. Thanks, everyone.
Thank you.